All right. Good morning. Namaste to everyone who has made an effort to join our session today. A warm welcome to everyone. Before we commence, here is a brief introduction about Lawyers Development Forum to all the incoming new participants. Lawyers Development Forum has been established to foster development and promote interest in the legal field. Not only do we actively organize academic lecture series, but also we arrange sporting activities for several advocates, including cricket matches and badminton tournaments. So we also conduct conferences featuring esteemed High Court judges and expert speakers from the legal profession who provide valuable guidance and insights. And as we all know, we host a Sunday Law Bulletin every Sunday where experts from various legal specializations share their knowledge and address key topics of importance. For this endeavor, we are forever grateful to Advocate Dr. Rajendra Anbhule, sir, Founder, President, LDF, Advocate Vijay, Shelar, sir, Secretary, Lawyers Development Forum, Advocate Abhishek Jagtap, sir, President, Lawyers Development Forum, Pune. Now let us move ahead. As we move ahead towards our program briefly, let me tell you that we have the honor of the presence of a very renowned figure, and he is Advocate Sachin Zalte Patil, sir. In today's Sunday Law Bulletin News and News session, he will be addressing the key topic, the role of expert testimony in criminal trials, art of cross-examination of medical expert in criminal trial, exploring the legal requirements for expert witnesses, challenges in presenting complex scientific evidence, and potential pitfalls in criminal cases. To begin with, here is a brief introduction of our expert speaker. Sir's educational qualification speaks for itself. Sir has secured distinction in Kolhapur University during his graduation, and he has passed with first class for his LLB degree from Pune University, as well as for LLM, he has passed with first class from Bharati Vidyapit University. And therefore, he has handled several famous cases and he has maneuvered these cases. The list of these cases are already put across different WhatsApp groups, but I would like to mention a few. Some of the mentioned cases are Bhima Koregaon case, Appa Londe murder case, the Gambar Kate murder case, Bajaj Alliance cyber fraud case, Viraj Jagtap murder case, Vishal Fate share market scam at Solapur district. For this particular case, sir has been as an assist to PP, Natarajan share market case, Ashtavinayak share market case. Sir has also been assist to PP in several other cases such as the Kate murder case at Baramati and Gautam Pashankar case. Not only that, sir is also a legal advisor for S. Raman Ram Private Limited, Chabri and Chabria Apus Private Limited, Plural Tech Software Company. Sir is a multifaceted personality and therefore he is a visiting lecturer at DES Navalmal Ferodia Ferguson Law College and Maharashtra Police Training Center at Khandala on criminal investigation. Sir has delivered several lectures across different bar associations throughout Maharashtra, and that makes him a very well-known and renowned figure. Sir, we are very pleased to have you here and we are eagerly awaiting for your session. Sir, you may kindly now proceed. Thank you so much, sir.
Thank you. So, friends, today we are going to deal with the various aspects of the criminal trial and particularly how the cross-examinations of medical witnesses to be taken. Before going to our lectures and the cross-examinations, let me very clarify that in the Indian Evidence Act, Section 45 to 51 are relating to the medical evidences, particularly opinion of experts. So these sections state that how the opinion of expert is relevant, how it is admissible. But friends, nowadays you know that the Indian Evidence Act has been changed and there is a Bharatiya Saksh Adhiniyam, and therefore there are several changes relating to medical opinion and the expert's opinion also. So now section 39 to section 45 deals in a newly enacted BSA regarding the medical opinion. So friends, earlier in a section 45 it says about who are the experts. So in that sections it is mentioned that only the persons, that is the persons relating to the art, science, foreign law, handwriting, and fingerprint expert. These are considered to be only the experts. But now, when a society changes, there are, you know that this act is enacted in 1872. There were no such technologies are available So under these circumstances nowadays, various technologies like a DNA test, like a serological expert, like a ballistic expert, and so many experts, including the forensic, cyber forensic experts are also. So due to that, we need to change the law and we have to insert it. These medical witnesses are also the expert witnesses. So now, keeping this in mind, the intention of the legislature has to amend this law, and they have inserted the words in section 45 that these four persons, for the five persons, along with any persons of any field, is considered to be the expert. So now, along with these five persons, now whatever I have mentioned, that the serological expert, DNA experts, now I have also narrated that the cyber forensic expert, ballistic expert. So now the word inserted of any another field. So now the definitions of the expert has been widened today in our section 39. So this is the first change. Now you already know that in a CRPC, there is a provision dealing with the section 293 and 294. These are the two provisions which deals with what happens that when a trial starts. So you already know that when a facts already admitted, that did not to be proved. So under these circumstances, prosecution used to give this list of the witnesses. So in that circumstances, we have to admit this the evidences which is put forward by the prosecution with a view that trial should be curtailed. It will save the time of the court. And there is also section 293 which states that no formal proof of certain particular witnesses are not required. So under these circumstances, what happens that during the earlier days in the Indian Evidence Act, in earlier CRPC, only we know that the CS, the chemical analysis report is admissible without any formal proof. Now there is amendment. These sections are inserted in a BNSS. These are dealing with section 328 and 329. You will learn these two sections, and these sections say that also the report which is submitted by any medical experts, including the ballistic expert, DNA expert, serological expert, or any cyber forensic expert, these reports are also directly admitted. So in the circumstances when this documents has been filed on the record, the prosecution need not to prove these evidences by way of examining the witnesses. So there is a recent changes in the BNSS. This change has been occurred with a view that the time span will be there will be no the trial will be curtailed in a time period, specific period. So now when you have the charge sheet has been filed and the documents which is submitted by these experts can be exhibited directly, you know that only exhibiting the documents is not sufficient. That document has to be proved by way of examining. Who is author of that document has to be examined. For example, a sale deed has been filed on the record. Mere filing of the sale deed is not sufficient. We have to examine the parties. We have to examine the scribe on this as a witness in this document. But there is an exception to this rule because certain documents are presumed to be genuine. No formal proof of documents is necessary. So under these circumstances, nowadays, the report which is submitted by the chemical analyzers, by the ballistic, by the serological expert, that can be directly exhibited. So now question in the mind, if we want to challenge these documents, because sometimes this, for example, the DNA reports are against the accused persons, they prove his involvement in a crime. So these are incriminating circumstances. So under these circumstances, what remedy available to the accused persons? Because these documents can be directly admitted, can be read in evidences. Under these circumstances, it may be implicated the accused person. So what remedy available for the accused person is that he has to make an application to the court and stating therein that, sir, I do not want to admit this document. I want to challenge the admissibility or genuinity of this document. So please call the witnesses. Under these circumstances, when applications has been filed, the court will ask the prosecution to examine these witnesses. For example, if there is a DNA test, DNA report, and this DNA report confirms the identity of accused persons. So under these circumstances, if accused wants to challenge this DNA report, he has to make an application to the court, and by in that application, he has to state that this witness may be called as a witness, prosecution witness, and under these circumstances, we have opportunity to cross-examine. We can cross-examine. We can challenge the identity of this DNA report by way of effective cross-examination. Now, these are the two changes which is occurs in a expert's opinion. The third change, that so far as the earlier days, there is no such a the electronic medium is there. So nowadays you can cross-examine the persons without calling him in the court by the video conferencing. You can cross-examine the witness. So these changes has been occurred in nowadays. Suppose one person who has conducted the PM, the doctor, and doctor left his job and now he is residing in America. So in earlier days, it is very difficult to send the summons and call the witnesses in the Pune for the trial, for the examination. So now there is a changes. You can cross-examine the witness. You can take the chief examinations on the very electronic media. That is the video conferencing, and other media are also available there. So this is the recent change. And second, the fourth change is that the word say that suppose the doctor who left the Pune, who has conducted the PM in a Pune hospital, and the witness is to be called for the examination of that witnesses. But now this person is not available, either he died or either he left the Pune. In these circumstances, the law which is amended, it says that you can examine any persons who is acquainted with the fact of the case. So his junior attendant who has also available at the time of PM notes, we can examine that persons, and from that we can exhibit the PM notes. So this is the change, because you already know that there is a delay in trial. Sometimes witnesses are not available. They left the job. They do not know the addresses. Also, sometimes the person has been died. So to tackle with these problems, any persons who is acquainted with the facts, that words has been inserted. So the persons who has conducted the PM which was not available, so the prosecution can examine any persons who is acquainted with the facts. That means any junior medical officers can be examined on that point, and from that the documents can be exhibited. So keep in mind, there are recent changes in a BSA, and these changes we have already dealt with. Now we will proceed with the next topic, or next key point, that what do you mean by medical evidences, what is relevancy, and how it is to be admitted. First, keep in mind, there are two types of evidences, that is substantial piece of evidence, and another evidence is a corroborative piece of evidence. So what is difference between these two is that, see, I will give an example. Let A stab B, and C is an eyewitness in this case. Now C has been called, summoned, and he is going to depose before the court by of chief examination. He said that yes, I was passing towards my house, and when I came in front of the court, there where I saw that the A is holding the knife, and A stabbed the B into the chest, and B died. This is the version of an eyewitness. So if the court feels that this witness is creditworthy, in that circumstances, court can convict the accused persons without any further corroboration. So these witnesses, like a witness of the eyewitnesses, witness of the prosecutrix, so these are the considered to be the substantial evidences for which no corroboration is required. But friends, the medical evidence is not a substantial evidence. Keep in mind, medical evidence is only the corroborative piece of evidence which can be used only for the corroborations, whether it is support the version of prosecution or not support the version of a prosecution. So whenever there is a medical evidence, one side, and the eyewitness count, so which will be prevail? So under these circumstances, law says that the eyewitnesses count is always prevails over the medical evidences. When there is a medical evidences versus eyewitness count, the eyewitness is always prevails. We cannot discredit the witness by way of medical evidences. But keep in mind, this is not a correct proposition for law. Law says that when a medical evidence is totally contradict with an eyewitness's case and renders the possibility of the prosecution case is highly improbable. In that circumstances, medical evidence can be used for discredit the witness of the versions of the eyewitness. I will give one example. Suppose this is the case that A fired bullet at B and C is an eyewitness. Now C is coming with the case that yes, I saw that A is holding the gun in his hand and he has fired and the bullet hit into the chest of the B and B died. This is the version of the eyewitness. But now if a PM notes has been conducted and in this PM notes it was revealed that there is no injury at all. So under these circumstances, now doctor come to the court and depose that I do not find any bullet injury or I do not find any traces of the bullet. So now this is the medical opinion of the doctor, which totally contradicts with the version of an eyewitness. So under these circumstances, we can disbelieve the eyewitnesses. If you take the cross-examination of the doctor, and by way of effective cross-examinations, we brought on the record that there is no such a bullet injury which can be found. So under these circumstances, we can consider that the eyewitness version is totally wrong. So the correct preposition of law is that we cannot discredit the eyewitness count only by the medical evidences, but 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 when there is a totally contradictions between the eyewitness and medical evidences. In these circumstances, eyewitness count can be discredited. So, friends, we'll come to the next point, the basic concept of the medical jurisprudence, and without knowing them, you cannot do the effective cross-examinations of the doctor. I will also give certain key points how the cross-examinations of the medical witnesses to be conducted. What are the exactly the key points on basis of what on what basis we can cross-examinations of the witnesses. But let's start without knowing the basic things. See, the medical jurisprudence is a very technical subject, but that subject is no such a hard. You can, when you learn about the basic concepts of medical science, under these circumstances, you can effectively cross examinations of the doctors and also the medical experts. So there is a one concept that is rigor mortis. See, the rigor mortis means, this is the Latin term. Mortis means after that, rigor means a muscle. So whenever there is a stiffening of muscles, this is called as a rigor mortis. So you know that when person is alive, there are the chemical changes in the body, there are secretion of enzymes, chemicals, and we are alive. For example, somebody says that, okay, pull the door. Under these circumstances, our brain gives the signals to our hand, and one, suppose this is my hand, and to get the object. So under these circumstances, there is a muscle movement. One muscle gets contraction, one muscle gets the other muscles. Therefore, there is a our brain gives the stimulations to the muscles. Under these circumstances, muscles uh, works. But one person's died. Under these circumstances, there is no such a signals, there is no such enzymes and their chemical changes. So now muscles start stiffening. There is no working of the muscles. It is called as stiffening of muscles is a rigor mortis. So it starts from our head. When one person's died, the rigor mortis started. The rigor mortis gets started from our head towards the toe of the legs. So the rigor mortis starts from the head and it ends with the toe of our leg. So how we have to use this rigor mortis? So for that purpose, there is a rule of 12, which says that rigor mortis starts after our death and it will fully develop within the 12 hours. So it starts from the head to the toe of our legs. When the 12 hours has been lapsed, the rigor mortis fully developed. That means what? Our body fully get stiffened, and therefore there is a the rigor mortis has been fully developed. So this rigor mortis, am I audible to all of you? Am I audible?
Yes, sir. Yes, sir. You're audible, sir.
So you are comfortable with the English language, or may I speak in Marathi and English? Whether the language will be
Sir, I think
see
both should be comfortable, sir. No problem.
what
I think
what happened, that is a very technical subject, and
yes, sir.
I am not saying that I am here only to speak in English. If you are not comfortable, I can speak in and also Marathi. Will get the better idea. What
No problem.
language you will prefer?
Sir, both can be okay, sir. You may proceed as you feel comfortable in. No problem. दोन्ही ही
Uh,
चालू शकते, sir.
all the students are from Maharashtra, na?
Sir, we do not have the count, but it might be a mixed pool of students also.
So the rigor mortis, there is a rule of 12 which says that the rigor mortis start after the death of the persons within the 2 or 3 hours, and it remains till the 12 hours. So in within the 12 hours of the death of the persons, rigor mortis fully developed. It remains as it is after further 12 hours. So within the 24 hours it remains, and after 24 hours it gets starts passing off within the 12 hours. So first 12 hours it starts, it's fully developed. After the 12 hours, next 12 hours, it remains as it is. And after this 24 hours, it started passing off, and within the 12 hours, it lapses. So this is called as rule of 12. It is called as rigor mortis rule of 12. So now some students are raising their hand. For what purpose they are raising their hands?
Sir, right now they are muted. Probably if they have questions, they will be posting it later on. If you would like, I may unmute them and they may ask the questions right away if there's any difficulty. Should I do
No,
that, sir?
the question and answers will be done at the end of our lectures. If you are
Yes, sir.
we are dealing with this in the middle of the program, it will cause disturbance to all the students. We will do this at the last moment, right?
Yes, sir.
So I will give you one example. That there is a last scene theory. Suppose A and B went toward the jungle. C saw that this persons are left towards the jungle, and then after only B came back. So this is called as last scene theory. So under this last scene theory, when a circumstantial evidence case is based upon the circumstantial evidences, the rigor mortis plays very important role, because when a PM has been conducted, in that situation, there is a concept time since death, that when the person has been died at a particular point of time before conducting the PM. Suppose the body has been found and PM has been conducted, suppose for example, at the 12 PM. And during this conducting of the PM, doctor can come to the conclusion that this person who has died prior to the 3 hours, prior to the 4 hours, prior to the 5 hours of the starting the point of the PM. So this is called as time since death. Means what? At what a particular time person was died, that can be confirmed during the time of the PM. So in a circumstantial based case is based upon the circumstantial evidences. In this case, the time since death is very important aspects, and that has to be proven by the prosecutions by way of proving the time since death. Why this time since death is important? Because, for example, there is a case of last scene theory. I have already narrated you that. What do you mean by last scene theory? That suppose A is an accused person, B is a deceased, they left towards the jungle, and then after only A came back. And then after the B was found in a dead situation, in a dead conditions. So now this is called as last scene theory. Means what? Prior to the death of the deceased, the accused persons and deceased found alive. For example, at 11 a.m., both was found alive, and then after on 12th of PM, the deceased was died. So on 11th of AM, this person was found alive, both persons. So this is called as last seen theory. So why this principle of last seen is very important? Because the our in Indian Evidence Act, there is principle of 106, which says that when the specific facts is within the knowledge of the accused persons, then this accused person has to explain what happens to the deceased. That means the death cannot tell the lie, tell the tale. The person who is allowed the tale. So this is the concept based upon the specific facts within the knowledge of accused person has to explain. When the prosecution proves the last seen theory, in these circumstances, burden shifts on the shoulder of the accused person, and accused person has to explain what happens to the deceased. So when the prosecutions prove the last seen theory, then only the burden shifts on the accused persons, and if accused persons has not rebutted this burden, then definitely it will go against the accused person. This is the law. So when you are successfully proving that there is no last seen theory, under these circumstances, there is no question of shifting burden on the shoulder of the accused person. So you have to disregard, or you have to discredit the last seen theory. And how it is to be discredited? By way of effective cross-examination. Suppose last seen theory which is demonstrated by the prosecution is 11 a.m. Both accused persons are deceased found alive at 11 a.m. and then after the deceased was died and he was found dead. So under these circumstances, if you effectively cross-examine the doctors and you have brought on the record that the persons whose time since death is prior to the 11th, that is the persons was died at 10 a.m. by way of effective cross-examinations of the rigor mortis, then you can successfully prove that the last seen theory is not applicable in this case, because as per the case of the prosecutions, as per the PM notes, and as per the case of the rigor mortis, this was died prior to the last seen theory. That means last seen theory, which is put forward by the prosecution, is not correct, or it is a wrong concept. So under these circumstances, you can disregard or discredit the last seen theory, and there is no question of shifting the burden. This is the concept of last seen theory. So now we will move to the next point, that is the food contents. See, the time since death can be calculated by the contents of the stomach. So person was died. So for example, when person was alive, we know that when we take the foods and there is a certain metabolism occurs in our stomach, there are certain acids, enzymes, and therefore the food get digested. So within the 5 hours, when the persons take the food, that has been digested within the 5 hours when a person was alive. So complete digestion of the food required 4 to 5 hours. But a person's died. Under these circumstances, there is no metabolism, and the food contents remains as it is. So there are the concepts that semi-digested foods may be found in the stomach of the person. Suppose a person's taken the food and then after within a 1 hour or 2 hours, persons died. That means what? After they taking the food, the only within the 2 hours the persons was died. That means there is no complete digestion of the food, because after the death those enzymes will work, and under these circumstances there is no complete digestion of a food. So you can found a semi-digested food in the contents of the stomach of the person. So after conducting the PM and after the conducting or examining the food contents in the stomach, and if the semi-digested food was found, that means persons has taken his food prior to the 2 hours or 3 hours. So from that we can come to the conclusion that the persons might have eaten something prior to the 2 hours, 3 hours, and if the no contents of the food has been found, that means the person has taken the food prior to the 5 hours or 6 hours. When a semi-digested food has been found, that means person has taken the food prior to the 2 hours or the 3 hours. If no digested no contents of the foods, all every contents has been digested, no contents has been found, so we can come to the conclusion that persons might have taken their food, his food, before 5 to 6 hours. So this is the concept of the food content, how we have to use in our cases. So far as the murder cases and the last scene theory is considered, this food contents and times in death can be very useful to discredit the credibility of the witnesses. I will give an example. There is one case that the boyfriend taken his girlfriend towards one mandir, and there where they have taken the prasad in that mandir, and the pujari of that temple has given the last scene theory. He came to the court and said that yes, this is the boy who takes the girl for performing the puja in the mandir, and therefore I have given a prasad to that lady. And then after, behind that mandir, this lady was found dead within 1 or 2 hours. This is the case of the prosecutions. That means at 11, both came in the mandir. They took that they performed their puja, and then after the pandit has given the prasad in a form of laddu to the deceased at 11 a.m. And immediately after 1 hour, the lady was found dead behind the mandir, and therefore the pujari, the pandit, came before the court and said that this is the accused person who's taken the deceased and he has committed the murder. There is a last scene theory. There is no eyewitness. So as I have already stated to you that when there is a persons, there is a last scene theory. That means facts within the knowledge of the accused persons. So he has to explain. Generally, the burden is always on the shoulder of the prosecution. He has to prove their case beyond the reasonable doubt, and the accused persons cannot explain anything. But there is a exception to the general rule that when the facts are within the knowledge of the accused persons, he has to explain what happens to the deceased, because there is a last scene theory and he must know that what happens to the deceased. So under this preposition of a law, burden shifts on the shoulder of the accused persons and he has to explain what happens to the deceased. So to press into the service, the section 106, the prosecution has to prove the basic foundation of fact that there is a last scene theory. And in this case, the prosecution has examined one pujari and they have proved the case of last scene theory from the mouth of the eyewitness of that pandit. But when the doctor came to the court, and we have examined this doctor, and we asked certain questions to the doctor that, doctor, you have conducted the PM. Yes. Under these circumstances, you have not found any semi-digested food. Doctor says, yes. That means what happens, Your Honor, the doctor, we asked to the doctor that this lady has not taken anything prior to the death within the 2 or 3 hours. He says, yes. So now, in one side, medical evidence says that this lady who has not taken any food prior to 2 hours or 3 hours, and particularly case of the prosecution, as per the version of that pandit, says that this lady came to the temple and at 11 a.m. I have given the food. So now medical evidences and the eyewitnesses count. There is totally contradictions between the medical evidence and eyewitness. Medical evidence says that no food has been taken. An eyewitness says that food has been taken. Under these circumstances, if really she had taken any food at 11 a.m., definitely the person was died in 12 a.m. Under this, the 12 p.m. Under these circumstances, there must be a food in the stomach of that lady. So under these circumstances, due to the effective cross-examination of doctor, the last scene theory has been discarded. So this can be used in the cross-examination. There is similarly a rule of 9. In the burning cases, there is a rule of 9. So I will explain this more details during the course of lectures. So now we will particularly come to the next point, that how the doctor's cross-examination is to be conducted, particularly in cases of murder, in cases of rape. So we will next move to the next point, that is the art of cross-examinations of the doctor. First rule, keep in mind there are 10 commands of the cross examinations, out of which this first command is that Don't ask the questions of which you do not know the answers. So this is the first command. If you are not knowing the answer which you have been put to the witnesses, so don't ask the questions which we are going to ask. You do, if do not know the answers, you cannot ask these questions. This is the first rule, keep in mind. Second rule is that don't give a chance to the doctor to explain. So whenever the witness come during the cross examinations, don't give the chances to the explain these situations. It will be definitely hamper your cross examinations. Particularly the cross examination is relating to the access the truth from the mouth of witnesses, and during your cross examinations you can control the witnesses and you cannot allow the witnesses to explain the situation. These two rules is to be keep into the mind. So now let's start some examples. I will give certain examples in cases like a burning cases. There is a in a suicide and in burning cases. I will give the two aspects of the how to cross-examine the medical witnesses. In cases of the bride burning, there is a cases of burning of the persons, and the persons was died due to the burn injury. But what happens that there are three aspects. One is the persons died due to the accident. Second is persons died due to the suicide. And third situation that a person died due to the homicidal death. So whenever there is a homicidal death, the prosecutions bring the home the guilt of the accused persons for the section 302, and there is a suicide. This is the 306, and for the accidental purpose there is no such a punishment. So when an incident occurs, the police concocted the story. The family members of that the persons by afterthought prepare such a false cases, and they try to implicate the persons for the purpose of the murder. For example, the case that the person, that is a lady, was suffered due to the bursting of the stove. There is a bursting of a stove, and during that bursting of the stove, she gets suffer certain injuries. That is burn injury. She was admitted in the hospital. There were parents of that lady, and the wife came over there, and they asked the lady, they tutored that wife to file a false case against the husband. Now, in the form of dying declarations, but tutored the virgin, she narrated that my husband used to demand the dowry, and therefore he came to the house in drunken conditions. He poured the kerosene. My father-in-law was present. He assaulted me, and my mother-in-law ignited me, and therefore I suffered burn injury, and I was admitted in the hospital. So now she has concocted the narrations. Particularly, she was burned due to the bursting of the stove. There is accident case, and now all persons, including the police officers, try to implicate this in-laws and the husband in a case of murder. So how we have to bifurcate the accidental cases in burn case and the homicidal death in burn cases? So that aspect is to be teens the medical jurisprudence, and you can brought or you can demonstrate to the court that this is not a case of homicidal death, it is a case of accidental death. So for that purpose you have to keep in mind that the PM notes, there are generally there are 21 columns, out of which 17 columns deals with the injuries. So in the 17 column number 17 of the PM notes, there is always you will find certain injuries. So from that, if you peruse this column number 17, you will get the idea of the injuries inflicted on the deceased. So whenever you are going to cross examination of the doctor, two columns are very important. That is last column, that is 22 or 21 column, cause of death, and column number 17, that is the injury which is found. There are two types injury, that is internal injury and external injury. So in case of a burning, how to bifurcate the accidental case with the homicidal death? I will give certain techniques. This is due to my experience. I have conducted so many cross examinations, so you will not find any books. But there are certain techniques. By these techniques, you can bifurcate the accidental and from the homicidal. First thing is that keep in mind Whenever the accident occurs in a bursting of the stove, in that circumstances, every injury is a frontal side. So, suppose, imagine that one lady who is cooking a food and he is standing or sitting in front of the stove. Suddenly, bursting of a stove, burnal of that stove bursts, and there is a certain injuries on the front side only. If because because when the she is sitting in front of the stove, suddenly the stove get burst and the injury are inflicted on the front side. So there is no injury on the back side. But when a person's pour kerosene into the body of the disease and inlighted with the mastic, under these circumstances, injury will be backside and the front side. So there is no injury at the back side. That indicates that it is a case of accidental. And if there is a injury from the both side, that is front side and the back side, this is the indications of the homicidal death. Keep in mind. So this is the first criteria. Second thing is that you know that the kerosene is known for the characteristics of odor. You can find the kerosene by the smell of this kerosene. During the bursting of the stove, only the the kerosenes will not sprinkle on the clothes of the accused persons, and therefore there is no such a smell to the clothes of the deceased. When after the deceased was died, inquest Panchanama has been conducted and the burning clothes pieces was sent to the chemical analysis. And in that chemical analysis report, if there is a kerosene was found, that means what? The persons was died due to the kerosene spouts on the persons, and there is a mastic has been enlightened the persons and died. So finding of the kerosenes in the CA report on the clothes, it clearly indicates toward the homicidal death. And in a case of accidental, these non-finding of the kerosenes onto the burning place of the clothes is always demonstrate or always indicates that this is the accidental death. So these two things has to be keep in mind. The third criteria, that when the kerosene was powered on the body and the person was enlightened with this mastic, in these circumstances, the injury which is found on the body are the deep injuries. And in case of accidental death, right, only the flames, due to the flames of this bursting of the stove, the body gets burned. So powering a kerosene and then after burning the person is different thing. And only due to the flames of that burning stove, the persons got injury. This is a different situation. The kerosene is a corrosive substance. Before persons, if any persons pour kerosene on any other persons and enlightened with the mastic, in these circumstances, the injury is always deep injury. And in case of accidental cases, the superficial injuries are there. There is no deep injury. So whenever you found a column number 17, in that column number 70, doctor mentioned that injuries are superficial or injuries are deep injuries. You have to keep in the mind that when there are superficial injuries, in that circumstance, it is tending towards the accidental death. And if there are deep injuries, then in that circumstance, it is case of homicidal death, means the story of prosecution is correct. And if you find the superficial injuries, that means it is a case of the accidental death. So, see what happens that whenever any case occurs of the burning and the patient was admitted in the hospital, she narrated or he narrated certain the dying declarations, and that is always in a certain situations it is afterthought dying declarations, it was tutored, and there is no such a true story what is brought on the record that it is an accidental case. When there is circumstances, I already pointed out that the burden is always shouldered on the prosecutions to rule out the possibility that it is accidental death, it is homicidal death, or it is a case of suicidal. So prosecution has to prove that it is a case of the homicidal death. So when the doctors came for the examination of the chief, doctor said the person was died due to the burn injury and it is maybe the possibility of the homicidal death. Under these circumstances, you have to cross-examine the doctor and particularly on these points of the aspect to bifurcate the case of suicidal from the accidental and from the homicidal. If you cross-examination doctor on the suspect, doctor see to bifurcate the case of accidental from the homicidal, what criteria you put forth or would lay down. So you have to ask that the injuries, so the front side injuries is said that demonstrate that it is a case of accident. Doctor says yes. So non-finding of the any injuries on the back side, it leads towards the accidental death. The doctor says that yes, you do not find any injury on the back side, doctor. So doctor said that it is maybe the possibility of the accidental death. Doctor said that yes. So this is the art of cross examinations. First, you must know what is the exactly the medical jurisprudence, how we have to bifurcate. You have to, in a cross examinations, you have to ask these questions, then how you have to bifurcate. That is the methodology you can use for bifurcating accidental death from the homicidal death. And you have to mention in your examination the symptoms or the criteria of bifurcating the accidental death from the homicidal death. Under these circumstances, you can draw the conclusion from the effective cross examinations, and you can demonstrate to the court that this is the case of the accidental, not the homicidal. But that can be done only by way of effective cross examination, as I already stated. So when you ask or cross examine the doctor, particularly on the point, for example, in this same case, if I ask the doctor, see doctor, in these circumstances, there is no such a see doctor, for bifurcating the accidental death from the homicidal death, what criteria you laid down. So I ask the questions that the depth of injury is one of the aspects or one of the criteria which can be taken into consideration during bifurcations of the accidental death from the homicidal death. Doctor said yes. So doctor, see, the deep injury means the person was died due to the homicidal death. Doctor says yes. See, doctor, when injuries are superficial in these circumstances, we can consider that it is accidental death. Doctor says yes. So, under these circumstances, you can brought from the mouth of the doctor that you found in this case the superficial injury. That means persons might have died due to the accidental death. Doctor says yes. So, your duty. So, prosecution's duty is always prove their case beyond reasonable doubt. But it's not your duty to prove your case beyond reasonable doubt. Your duty is to prove your case by so you have to ask upon the possibility, preponderance of probability. You can ask this type of questions to the doctor. Also, I will demonstrate one thing. The next thing is that so far as the suicide and the homicidal death. Suppose one person strangulate B, gala आवळला. So this is called a strangulation. Under these circumstances, sometimes what happens that the deceased committed suicide in a house by hanging herself, and the relatives of the deceased, the particularly the wife, file a case that the in-laws has committed the murder by strangulating that wife. The false case of 302 police detected the crime and they have filed the charge sheet. Under these circumstances, BPO was successfully brought on the record. This is the case of homicidal, and this is not the case of this is the case of suicide and not the case of homicide. Then there is a chances of acquittal. So, how to bifurcate a homicidal death from the suicidal death? See, whenever the person's committed a suicide, right, in a house or in a home, under these circumstances, there are 7 criteria to be taken into considerations how we bifurcate the suicide from the homicide. Suppose a person want to commit a suicide. What exactly happens that he tied the knot onto the rope and then after he committed by hanging himself. So whenever there is a suicidal note, the injury that is called a ligature into the neck is the injury mark is always oblique in nature, because the person body gets suspended in these circumstances, and the ligature mark is always oblique in nature. It runs from the ear to the neck. So the oblique nature of the ligature mark is considered to be the homicidal end. And if it is a parallel, ligature is parallel, it is called as a strangulation case. So this is the one of the important aspect is to be taken into considerations. You have to have certain knowledge about that, and when you realize during the postmortem or by perusing the postmortem, there is always ligature mark, and doctors mention that whether it is oblique or parallel, when this ligature mark is an oblique in nature, it is a sign of suicide, and when the ligature mark is parallel, it is a sign of homicidal death. So you have to ask these questions to the doctor, that to bifurcate the suicide from the homicidal, the nature of the ligatures is important, size of ligature is important, and also the directions of ligature is important. If the ligatures marks in oblique in nature, so it tends toward the suicidal death, and if it is a parallel, in this circumstance, it's tending towards the homicidal death. In this case, you have found that the ligature is oblique, so that means suicidal possibility cannot be ruled out. Doctor said yes, there may be a suicide. So under these circumstances, the case of prosecution is homicidal strangulation death, and you brought on the record that this is the suicidal possibility is there. So under these circumstances, you will get the benefit of doubt, because there are two views. One view is supporting to the homicidal death. Your view is supporting the suicidal case. In these circumstances, view which is favorable to the accused person is to be taken into considerations by the court, and you will get the benefit of that, and you will be get acquitted. So keep in mind, by way of effective cross-examinations of the doctor, you can cross-examine the doctor, and you will get succeeded in the case. Second aspects, when in a suicidal case, there is a dribbling of saliva. There is a saliva gland which is situated in our neck. In case of suicidal, when a person's alive person's hang himself or herself, there is a dribbling of saliva from the mouth. And in case of strangulations or the persons who is a first murder and hang, under circumstances, there is no dribbling of saliva. So when you found any saliva into the mouth, into the onto the clothes or during the floor, you will get the idea that this is the case of suicide. So under these circumstances, you have to cross-examine the doctor that, sir, dribbling of saliva is a symptoms of the suicide. So under these circumstances, the inner spot panchanaama, there are symptoms, certain traces of the saliva. So you can ask the doctor, if there is a saliva, you find a saliva in this circumstance, it is case of suicide. So under these circumstances, on the spot, there are some traces of saliva was found. That means it is a case of suicide. So doctor said yes, the finding of the saliva onto the mouth or into the mouth or onto the clothes is a symptom, or it is a sign of the suicide. Under these circumstances, you will win the case. Now it is a 11:55. 57. So if you have any questions, you can ask the question. This topic is very long, and during the short period, it is very difficult to cover all the aspects of the case. So I summarize or I conclude that for the effective cross-examination, first you have to know what is the medical jurisprudence. You have to study the books written by the Modi, Parekh, Bernal Knight. These are the three important books, out of which the Modi's language is very hard language. If you are not having science background, you can learn the Parekh book, and from that Parekh books, you will learn some important aspects, and by you can ask the cross examinations to the doctor by referring these books, because if you want to contradict doctor, you have to give him the reference, the propositions of the Parekh book. You have to refer these books, and you have to ask whether you are agree with that. Now this is the important aspects of the cross examination. So today, now it is 11:12. So I conclude this topic. So if you have any queries, you can ask the doubts about the same.
Yes, sir. Thank